Well, hello everyone, and a very warm welcome to this third instalment of 42 Bedford Row's webinar series, looking at some of the practical aspects of applying for and obtaining antisocial behaviour injunctions under the Antisocial Behaviour Crime and Policing Act 2014. My name is Paul Fuller. I'm a member here at Chambers, and today I'm joined by Krishma Patel, and together we're going to give consideration to some of the factors that should be borne in mind when gathering evidence to support an application for an antisocial behaviour injunction, and perhaps, as the case may be, an attached power of arrest. Standard disclosure before we disclaimer before we kick off. This, of course, is a very whistle-stop potted summary of some of the issues in this particular area, and it shouldn't be considered to be a substitute for properly informed advice. So we're talking about evidence today and evidence gathering, and perhaps the best starting point then is to give consideration to what evidence is. Evidence is information or material, oral or documentary, real evidence that proves a fact that assists the court in deciding the issues in a case. That might seem like common sense, and indeed it is, but what that definition also tells us is what evidence isn't. Evidence is not conjecture, it's not speculation, it's not legal argument, and neither, unless you're an expert, should it be opinion. There's no place in civil proceedings for conjecture or speculation. Legal argument is for pleadings and skeleton arguments, and ultimately for the trial advocate, and opinions, as I say, are really the sole preserve of experts whose opinions matter and carry weight. Lay evidence, though, should be limited to information or material that proves or supports a fact that goes to the issues in the case. And that last point, the need for evidence to go to the issues in the case, can't be overlooked. A witness statement might contain all the hallmarks of evidence, but it won't be admissible if it's not relevant. So that's to say, it has to be relevant to the issues in the case. Now over to Krishma, who's going to touch on the content of witness statements.
Thank you, Paul. So rules around witness statements, where can we find them? We can find them in CPR Part 32 and in the practice direction that supplements that part. Of course, in any case, whether it's an interim application or a trial, parties will rely on documents that will go part of the way to proving what is in dispute, but witness evidence is necessary to tell the story behind the dispute and to fill in any gaps that the documentation may leave. Under CPR 32.1, the court has got a power to exclude evidence that would otherwise be admissible and limit cross-examination in various situations. So given that the court can exclude either entire witness statements or sections of witness statements that include inadmissible and or irrelevant material, it is important, as Paul has said, to make sure that the material is relevant and appropriate. Generally speaking, a couple of rules to be familiar with regarding witness statements. 32.2, which says that evidence of witnesses, general rule is that any fact that needs to be proved by the evidence of witnesses is to be proved at trial by giving oral evidence in public or at any other hearing by evidence in writing. 32.5 says, deals with the use of witness statements at trial and where they have been served. Where a party has served a witness statement and they wish to rely on at trial on the evidence of that witness who made the statement, they must call that evidence, witness, to give oral evidence. Part 33 also, just to touch upon this very briefly, contains provisions about hearsay evidence, but Paul is going to touch upon that in due course in the next section. In terms of the form of a witness statement, relevant rule here is 32.8. It has to comply with the requirements that are set out in Practice Direction 32. The requirements in Practice Direction 32 are quite detailed, relating to both the format and body of a statement. Dealing with the format of a statement, it's dealt with, so 17.1, paragraph 17.1, for example, deals with headings, and then you've got 18.1 and 18.2, which deal with the body of a statement, which is really what I want to address. So 18.1 in Practice Direction 32 deals with what deals with the fact that a witness's statement must, as far as practicable, be in their own words and must be drafted in their own language, and it should be expressed in first person. It should also state details such as their name, their occupation, the connection to the proceedings, and the process by which it's been prepared, whether it's face-to-face, telephone, through an interpreter, etc. A witness statement, this is 18.2 of Practice Direction 32. It must also indicate which of the statements in it are made from the witness's own knowledge and which are matters of information or belief. And it must also set out the source of any matters of information or belief. Any exhibits that are used in conjunction with a statement should also be verified and identified by the witness and remain separate from the statement. And so just pulling all of that together in this particular area of law, if, for example, you've got a housing officer that's deployed to a relevant case involving antisocial behaviour, and that housing officer receives reports of antisocial behaviour, but they haven't witnessed this directly firsthand, if they are producing a witness statement in support of an antisocial behaviour injunction, they would need to state the sources of their information. So if, for instance, that source of information comes from a complainant who's drafted an email to that housing officer that sets out an incident of antisocial behaviour, it may be appropriate if if the complainant is willing to be identified, for that email to be attached as an exhibit to the housing officer's statement, which sets out the source of their information. But it is also very important to be careful in that situation, because it may be, and often it does occur in these kinds of cases, that complainants are often unwilling to be identified for fear of reprisal. So it may be that if that needs to be considered first, and it may be that if it's appropriate to append the source of any information as an exhibit, it may need to be heavily redacted to protect the identity of the complainant. But effectively, the rules say that a witness should be clear about the sources of their information, so the court can identify which statements are made from the witness's own knowledge. And the witness also needs to make clear what statements are based on belief, as I said, and which are made based on information from a third party. Now, generally speaking, for antisocial behaviour cases, as a rule of thumb, in terms of witness statements, I would suggest setting out the background to a case. Relevant events, allegations, those should be set out in a logical manner with a good amount of detail, and I'll come back to the level of detail shortly. Any exhibits that indicate a source of information or support any facts within the statement. If a statement is from a housing officer, any steps taken to resolve the dispute and the relationship between the parties to the court proceedings. Generally, in terms of preparation of witness evidence, it can be prudent in these kinds of cases to take a proof of evidence at a very early stage pre-proceedings from people that are in the best position to tell you about the facts of the case and the antisocial behaviour. It might be necessary to interview a number of witnesses before it can be identified who is the best place to give that evidence. And any proofs of evidence that are taken can then be used as a base to prepare a witness statement. But it's important to consider, when preparing witness statements, what are the facts that are actually in dispute. You obviously don't need to prove facts that are agreed, and your starting point should be, a good starting point is to compare and review the party statements of case, because those documents will tell you what exactly is in dispute, and that can then be used to inform what the content generally should be of your witness statement. So that deals with what generally should be in a statement, and we'll come on to the detail of that in a moment. But what should a witness statement not contain generally? Well, it shouldn't contain legal arguments such as references to case law or legislation. That, generally speaking, should be set out in the party's pleadings and statements of case. I'm now going to pass you back to Paul, who's going to talk about the quality of evidence generally, and then we'll come back on the level of detail in statements.
Thank you, Krishma. Well, you can see the slide there contains a quote from the case of Director of Public Prosecutions in Kilbourne, 1973, where the court observed that evidence is relevant if it's logically probative or disprobative of some matter which requires proof. And in deciding whether evidence relied upon by a party establishes an issue in dispute, the court is always going to have regard to the quality of the evidence, or to coin the phrase in Kilbourne there, the more probative the evidence is, the better the quality of the evidence. If the court takes the view that, albeit admissible, the evidence is not of a particularly good quality, then the court is going to attribute less weight to that evidence. What constitutes good quality evidence will depend on the specific circumstances of the case, but there are some general rules that are apropos. Contemporaneous evidence, for example, will always carry more weight than evidence that's based on a deponent's memory or recollections. For example, if a housing officer is attesting to some incident that happened some months ago, then their evidence is going to be more probative if it's supported with primary contemporaneous evidence in the form of, for example, diary notes, correspondence, perhaps emails or letters relating to the incident at the time of the incident, photos or maybe even CCTV footage, and of course there may even be police reports. On the point of CCTV footage and the quality of evidence generally, a recent case, Declan and Malloy, the BPHA Limited, that's a 2021 case, is an excellent example of the probative value of first-hand evidence, as I say, in that case, CCTV footage evidence. Mr. Malloy, a resident, was subject to an antisocial behaviour injunction. So the injunction had already been made. And that injunction prohibited Mr. Malloy from, amongst other things, using racist language or slurs or gestures, and from intimidating or attempting to intimidate his neighbours. The Housing Association then brought committal proceedings against Mr. Malloy for breaching the injunction, which, by the way, had a power of arrest attached to it. The Housing Association, in support of its committal application, produced the CCTV footage that it had, showing Mr. Malloy using a racist slur as he walked past neighbours' property. The judge of first instance was persuaded on the basis of the CCTV footage that Mr. Malloy must have intended in using that slur to intimidate his neighbours, and so he found that the injunction had been breached and accordingly gave Mr. Malloy a custodial sentence. Mr. Malloy then appealed that decision, arguing two grounds. Firstly, that the judge of first instance had applied too much weight to the CCTV footage in finding that Mr. Malloy must have intended to intimidate his neighbours. Mr. Malloy argued that actually it had just been a private conversation between himself and his wife, and that there was no intention to intimidate. He also argued that the use of these CCTV footage evidence was a breach of his Article 8 rights under the European Convention of Human Rights. That's respect for family and private life. The Court of Appeal dismissed Mr. Malloy's appeal, and in dismissing the appeal, Lord Justice Peter Jackson noted the complaint about the use of CCTV footage in this case is patently overblown. It is only to defend herself and her family from the appellant, Mr. Malloy's behaviour, that the neighbour has had to install CCTV recording equipment. The logic of Mr. Malloy's argument is that instead of putting up these defences, the neighbours should retreat to their home, leaving Mr. Malloy free to flout the court orders as and when he chooses, and without the inconvenience of being recorded from doing so. The judge said, fortunately, that is not the law. So a real working example there of how crucial and how useful that first-hand CCTV footage evidence was in an antisocial behaviour injunction case. Another area where the law will exercise particular caution when deciding the quality of evidence is where the evidence relied upon is hearsay. Hearsay evidence is defined as a statement made otherwise than by a person while giving oral evidence in the proceedings that is tendered as evidence of the matters stated. Not the simplest definition, perhaps, and deciding whether evidence is hearsay is not always the simplest undertaking. But in simple terms, where the witness attests to something that they witness personally, then their evidence will be first-hand. If they rely upon some other source to prove the fact, then their evidence is likely to be hearsay. So to take a working example, if the housing officer witnesses antisocial behaviour firsthand, then they're of course able to attest to that antisocial behaviour firsthand. If the housing officer, on the other hand, is informed about the antisocial behaviour by some other source, perhaps another resident, and they refer to that source within their statement, then that evidence will be hearsay evidence. Section 1 of the Civil Evidence Act 1995 provides that hearsay evidence is admissible in civil proceedings, but the court can attribute limited weight, in some cases no weight, to hearsay evidence. And in deciding how much weight to attribute to hearsay evidence, the court will have regard to all the circumstances, but in particular the non-exhaustive list that's set out in Section 4 of the Civil Evidence Act. So that includes a consideration as to whether it would have been reasonable for the applicant to have called the original maker of the statement to give evidence, consideration as to whether the original statement was made contemporaneously with the occurrence of the matters stated, whether multiple hearsay is involved, whether there is any suggestion that there is a motive to conceal or misrepresent matters by relying upon hearsay evidence, whether the original maker of the statement, or the original statement rather, was an edited account or made in collaboration with another party, whether there's any suggestion that the circumstances in which the evidence is adduced are such as to suggest an attempt to prevent a proper evaluation of the weight of the evidence. So, as I say, a whole host of factors there that the court can take into consideration, and that's a non-exhaustive list. The real takeaway here is that if hearsay evidence can be avoided, and if we can put forward primary evidence, first-hand evidence, then that evidence is always going to be better, more probative, it's going to carry more weight, it's going to be of a better quality. That can and often will mean then providing witness statements in support of applications given by more than one witness. So, for example, a housing officer might give a statement attesting to diary notes, police reports, and the impact of the antisocial behaviour on the housing management functions of the local authority or the housing association. Separately, though, you might have a witness statement or witness statements given by residents attesting to the actual antisocial behaviour that's complained about. Moving over to Krishma now, who's going to talk briefly about making sure that the witness statements address the issues in the case.
Thank you, Paul. So we know that witness statements are important tools in the context of these kinds of proceedings, and we're going to talk about what level of detail is useful to have in witness statements. But before we go there, I just want to review very quickly the conditions for granting antisocial behaviour injunctions. Onus is on the applicant to identify on balance that the perpetrator has engaged or threatens to engage in the antisocial behaviour, and it must also be just and convenient to grant the injunction in order to prevent the perpetrator from engaging in antisocial behaviour. Antisocial behaviour can be looked at in three ways. One, conduct that has caused or is likely to cause harassment, alarm or distress to a person. Two, conduct capable of causing nuisance or annoyance to a person in relation to that person's occupation of residential premises. Generally used when applied for by a housing provider, local authority or chief officer of police, but housing providers, local authority, chief of police, and are not limited to just relying on that definition. And three, conduct capable of causing housing related nuisance or annoyance to any person. Now, housing related is defined as indirectly or directly being related to housing management functions of a local authority or a social housing provider. Where the antisocial behaviour complained of impacts upon a social landlord's housing management functions, often you will see a social housing landlord will put in a statement from one of their professional witnesses in their employ to support the injunction application and to set out the impact that the antisocial behaviour is having on their management functions. From a housing perspective, that may be, for example, taking away resources, whether that be housing stock, whether that be staff that need to deal with the antisocial behaviour complaints, etc., just to explain how it's related to their management functions. We're now going to talk about the level of detail that should be within statements, witness statements, dealing with where there are allegations of antisocial behaviour or where there are incidents of antisocial behaviour. Where there is a specified incident, it is useful to identify who was involved, where it took place, when it occurred, what actually occurred, and how the witness was involved, if relevant and if appropriate, noting, of course, what we've talked about already, relating to witnesses that are fearful of reprisal. Now, in terms of, I've had a number of cases, Paul, I don't know if you have, but I've had a number of cases, for example, where we've had statements that are put in to support antisocial behaviour injunctions, and incidents are referred to within a statement, but there is basic detail missing, such as when, the date on which an allegation or incident occurred. And that does cause problems because, of course, a respondent has to be able to respond to the allegations or incidents that are presented and that are relied on. And if you don't have the basic detail that deals with, for example, what date or when this incident occurred, it does indeed cause problems in terms of a respondent being able to respond to that. It's also not very specific and quite vague if you don't have that level of detail. So I would suggest that in relation to each allegation or incident, that basic level of detail should be there within a statement. The effect of any antisocial behaviour or any incident is also very important because the statement should set out how did the incident or allegation result in alarm or distress, or can it be said it's likely to? Again, I caveat that with it's important to be as detailed as possible in relation to these allegations, but it's also important to balance that against the risk of identifying vulnerable sources of information. So redactions should be considered where necessary and where appropriate. Of course, a power of arrest can be attached to an antisocial behaviour injunction where a perpetrator has used or threatened violence, or if there is a significant risk of harm to others. So if an application for injunction is seeking a power of arrest, then any witness statement in support needs to deal with whether there have been any incidents or threats involving violence and why there is a significant risk of harm to others. Because effectively, the witness statement should be used to justify why a power of arrest is required. And so that the court can understand the reasons for why that risk exists and why there's a need for a power of arrest. Again, if an incident has involved a report to the police, it may be useful to exhibit any police reports or any documentation in that regard, but of course, always being sensitive to the source of the information and protecting any vulnerable witnesses. Which brings me to Paul's section now on vulnerable witnesses.
Thank you, Krishma. Yeah, I mean, certainly I've seen cases where potential applicants, local authorities, housing associations have abandoned applications or potential applications for antisocial behaviour injunctions simply because they don't have the evidence to support the application, notwithstanding it being quite clear that the potential defendant has been acting in an antisocial manner and indeed making residents' lives a misery and really impacting on the housing association or local authorities' housing management functions. And the reason for that is, of course, very often the first-hand evidence of this antisocial behaviour is witnessed by residents. And it may be the case that the residents who are best placed to attest to the facts in support of the issues are nervous about providing statements. And as Krishna notes, that's not unlikely if the defendant has behaved in an intimidating or violent manner and there's fears of reprisal. Practice Direction 1A of the Civil Procedure Rules is a relatively recent addition to the rules. It came into force in April 2021. And that practice direction is designed to ensure that vulnerable witnesses are identified early on and afforded appropriate protections so that they're able to give their evidence and so that the quality of their evidence is not diminished as a result of their vulnerability. Paragraph 4 of the practice direction then goes on to set out factors that the court can take into consideration when deciding whether a witness is vulnerable. And subsections E through G of paragraph 4 are particularly relevant in these types of cases. So the court can consider the impact on the witness of the subject matter of the case, the relationship that the witness might have with a party or other witnesses, for example, where there's been sexual assault, domestic abuse, or the practice direction says intimidation, and where there are other social, domestic, or cultural circumstances that the court bears in mind. So the rules, we can see that expressly recognise that witnesses may be vulnerable as a result of relationships with other parties where there's been an abuse or an intimidation, or there are social, domestic, or cultural factors. Paragraph 7 of the practice direction then goes on to provide that if the court decides that a party's or a witness's ability to participate fully and give their best evidence is likely to be diminished, then the court can order appropriate provisions to ensure that their evidence is given properly. And that can include concealing the address and or the contact details of the witness for appropriate reasons. Paragraph 10, forgive me, gone a bit too far there, goes on as well to provide other special measures which may be relevant. And these can include preventing a party or a witness from seeing another party or witness when they're given their evidence through the use of screens, allowing a party or a witness to give their evidence remotely by video conference, and indeed hearing a party or a witness's evidence in private. So as such, when you're gathering your evidence in support of a potential antisocial behaviour injunction application, if you take the review that the best evidence is to be given by a witness of a particular matter, whether that's a resident or it may well be a member of staff, but that witness is reluctant to give their evidence because of fear of reprisal, then you may wish to reassure them that the court rules provide quite wide-ranging scope for the court to take steps to ensure that the vulnerable witness is afforded protection so that their evidence can be given safely and so that the quality of their evidence is preserved. Over to Krishma now, who I think has got some closing tips.
Yeah, so just a couple of very brief practical tips. Often in cases involving antisocial behaviour, you see multiple allegations that stem over a long period of time. I've always found, it may be similar for you, Paul, but where there are multiple allegations, and there may also be lots of documentary evidence, using a schedule of allegations to put things in boxes and to identify certain allegations, and then to go across in a column and put forward what evidence relates to that allegation and cross-refer in that way can be incredibly helpful. So I'd suggest the use of schedules of allegations where there are cases involving multiple allegations, and where there is other documentary evidence as a way to sort of summarise all of the allegations in one place. Chronologies, I know this is quite basic, but particularly where you've got antisocial behaviour that's escalated over a period of time, can be quite useful to demonstrate to the court how that behaviour has escalated and over what period. Where in the infancy of even pre-proceedings, but where you've got, for example, a social housing landlord who has received reports of antisocial behaviour, it may be helpful to ask complainants or the complainant to keep a log or a diary to record contemporaneous incidents when they've occurred. Those logs or diaries can then in turn be used to take witness proofs, and can then in turn, if it is deemed that complainant is appropriate to give evidence, is willing to give evidence, can then be used to as a base for their witness statement. So those are just a few practical tips to assist at the very start of when you are thinking about bringing a claim or bringing an application for an antisocial behaviour injunction. We hope that in general you have enjoyed this webinar. It does bring us to the end of our webinar. Very grateful for your time today, so thank you for joining us. We have popped our email addresses on the screen, so if you do have any questions relating to specific cases or just generally about anything that we've touched upon or talked about, please do get in touch. But again, thank you very, very much for joining us, and we hope that you'll join us in the next webinar that will continue on with this topic, and I think we'll deal with defences. Thank you.
Thank you. Goodbye.
Bye.